All right. If everyone could take their seats, I'd like to just really quickly introduce Bill Baer. He really doesn't need an introduction, but I'm going to give him one anyway. He's currently a visiting fellow in governance studies at Brookings Institution and is one of the world's most respected competition enforcers. He's the only person to have led antitrust enforcement at both U.S. antitrust agencies, the DOJ and the FTC, and during his tenure as Assistant Attorney General at the Antitrust Division, he achieved unprecedented success in civil and criminal enforcement, bringing and winning more cases than at any point in its history. And, I know for me, he's just been an incredible, resource and, provided a ton of great perspective over the years. And I think he's probably one of the most important people connecting a prior era of antitrust thought to the current era, which is going in a different direction. And so please give Bill Baer a warm welcome. Thank you.
Thanks, Teddy, and thanks for that final thought. For those of us who've been in antitrust enforcement in Democratic administrations, to be the subject of as much criticism that the progressive movement threw our way required some real soul searching, and it's been the experience of a lifetime to engage with Assistant Attorney General Cantor and his team, Lena Khan, FTC chair, and her team, and work with them. We're all trying to get to the right outcome, and it's been fun to be part of that and to applaud their successes, their willingness to take on so many challenges. Thank you for setting this thing up today. Thank you for the morning panelists. I learned a lot. I thought it was thoughtful, interactive. The problem at my age is I'm going to forget all that I learned by the end of the day. But it is what it is. Even though I took some notes. But so we're here, to discuss, focus on remedies on the antitrust trial of the century, the second one involving Google in the last 11 months, and one of a series of trials of the century that we should be having in the next 3 to 4 years. And while trial of the century may be slightly hyperbolic, when you think of what's out there now, we've got the Google search remedy phase coming up on deck. We have the Texas ad tech case pending in the state of Texas. We've got monopolization challenges to Amazon, Meta, Facebook, Apple. I guess you'd include Ticketmaster, Live Nation, and other investigations that apparently are going on. So it is an extraordinary amount of appropriate focus on monopoly concerns in the tech industry. Appreciate today our focus is on remedies, particularly when it comes to Google. But I always remind myself when invited to speculate on remedies that you first have to find liability. And if you're going to sustain a remedy on appeal, it's got to be tied to the findings of remedy. And that is, I think, Judge Mehta has done a nice job applying the Microsoft criteria, citing either Supreme Court precedent in showing how you can build a factual and legal basis for a liability finding, and then we go on to figuring out what remedy is. I think the challenge this afternoon is on a practical level, how do we restore a competitiveness in these quite extraordinary pending high-tech cases? thoughtful and prolific antitrust guru, Herb Hovenkamp, who I've often described as my antitrust lifeline, recently authored a monograph called Tech Monopoly. And he offered kind of a simple recipe for thinking about tech monopoly issues. He named 3 ingredients to his recipe. First, you got to understand the problem. Second, you need to do something reasonably calculated to fix it. And third, you want to make sure you do no unreasonable harm. It's a nice, simple framework for thinking about it. It would have been helpful if he had proportioned the ingredients so you know how much of this and how much of that to weigh and put into the menu. But I think he'd be the first to say that you can't have a one-size-fit-all approach to these problems. They are so factually dependent. You need to think it through. But I thought I'd frame my remarks around his framework. Professor Hovenkamp first says, understand the problem. And I think we saw some of this morning. Here's where antitrust jurisprudence, I think, has made the most progress, appreciating network effects and first mover advantages, and see how they can cause markets to tip, how they can raise entry barriers, and allow bad actors not only to obtain, but obviously to maintain significant and persistent market power. And so with the help of the academic community, including panelists this morning, enforcers have learned a lot about how to understand what constitutes unlawful monopolization, how to differentiate that between legitimate competitive behavior. Their focus is on understanding what is illegitimate, what entrenches unfairly a monopoly, and then how to frame those issues in court, because you can be as smart and sophisticated as you want. We're dealing with judges who, for the most part, do not have antitrust depth, and presenting that evidence in a convincing way. The Microsoft decision some 23 years ago, I think, adopted a framework that has been useful. Judge Mehta applied it, and I think we'll see other courts considering the cases coming down the line to do that as well. So I think in answer to understanding the problem, Herb Hovenkamp's first thought, we are better positioned to prosecute successfully monopolization in the tech sector than ever before. The challenge that this conference raises is, now that the dog has caught the car, what the hell do we do about it? Thank you. And what Herb says, okay, do something reasonably calculated to solve the problem. But of course, there's the rub. That reasonably calculated frame is like a Rorschach inkblot test. It's what we think. Defendants in these cases and their supporters will argue that if any remedy is appropriate, and of course they're not going to propose any, it should be limited to cease and desist. The old Roman Catholic notion of go and sin no more. In Google search, I guess that means maybe no payments to be the default. Maybe they have to put up a search screen. But what does that really fix? I think we've learned this morning not very much. And it doesn't address the lock-in effect that so permeates these tech monopolies. And, choice screen, Christina this morning laid out that the choice screen, which was touted as something that would meaningfully open up search to competition, just hasn't worked. People default to their prior default. And so it's obvious, I think, to all, in this case, all but Google and its supporters, that more needs to be done to level the playing field where you have finding of unlawful monopolistic conduct. And that always, I think, needs to be the goal, finding ways to restart the race on a level pitch. If you think about it in any other way, you're allowing the unlawful victor to retain its unlawfully gained spoils. It is, in Google search, Tim this morning talked, I think, about sharing the white pages, as a classic example of a remedy that ought to be front of mind as DOJ and Judge Mehta go forward over the next few months. The panels this morning, I think, noted appropriately that the government has had some success over the years with restarting the race on a level, or at least a more level playing field. We saw that in 1956 with the AT&T consent decree, and again in '82 with the breakup decree, which was effective as of early '84, if memory serves. The IBM consent decree also in '56 opened up the nascent computer market to meaningful competition. And, thinking about the remedy, it's like making the white pages available. This notion of royalty-free IP licensing succeeded, I think, in both of those instances in opening up the markets like never before. It's less clear, I think, what the remedy ultimately negotiated in the Microsoft case in 2001 has achieved. There's debate about that. That was the victim of a change of administration. So the new folks came in and settled it quickly and quietly in late 2001. So in thinking about how to level the playing field, we need to think less about putting remedies in a structural versus behavioral package, and think more about what our experience actually teaches us that works. Some labeled the AT&T 1956 decree as behavioral, but licensing is a divestiture, right? A royalty-free license. So it's at the same time, the AT&T decree in 1982 is called structural because it did separate business units, creating the baby bells. But remember, and some of you weren't around at the time, but I'm sure at the time Judge Harold Green and his law clerks were well aware, there was a lot of behavioral requirements in that decree, and required an extraordinary amount of time by the judge and his clerks and a technical committee that eventually got set up to make sure that AT&T lived up to its obligation to ensure interoperability between the baby bells and AT&T, and between AT&T and its emerging long-distance rivals. But interesting, as I was thinking this through, it took more than interoperability to transform the landline and emerging cellular markets into something that was competitive. The secret sauce, I think, there turned out to be portability. That came later. The 1996 Telecom Act directed the FCC to allow us to own what we had mistakenly assumed were our phone numbers. But until Congress mandated and the FCC eventually implemented portability, it turns out we were just renting the phone numbers we called our own. We couldn't move them around, and so there was no competition. We were locked in. It took the FCC a long time to figure out how to make that work properly, but they did, and that portability deserves more credit than it gets for giving consumers meaningful telecom choices today. Although, just aside, maybe not as much choice if my successor at DOJ had joined the states in challenging the Sprint T-Mobile deal. But that's an aside. I digress. At the same time, make sure I've got my notes all set out here, right? Yep. I'm reminded recently of the thoughtful piece John Cuoca and Tomasco Valenti wrote 3 years ago, urging that breaking up dominant firms is more often than not the most meaningful path towards restoring a competitive landscape. And they cite examples both here and in Europe where it's worked. And they talk about looking for fault lines where you can cut into the granite and carves something out that is meaningful and doesn't require creating new companies and having long-standing supply and other kinds of relationship. So I think focusing on fault lines is a good way of thinking about where we are and where we need to go. Now, Professor Hovenkamp's third admonition for tackling tech monopoly is do no, he puts it in quotes, unreasonable harm. Now, it's hard to argue at that point, too, but its application may be in tension with his previous admonition to do something reasonably calculated to fix it. But if he means don't harm the market, do no harm means don't diminish competitiveness, and instead enhance its competitiveness, that tension to me seems to go away. But a meaningful remedy, one that actually levels the playing field, is going to harm the monopolist. It has to. The monopolist needs to be stripped of the tools it unlawfully used to maintain its monopoly position. How you do it is part of what we're discussing today, but that has to be the bottom line. They maneuvered, they got monopoly rents. In some cases, Google allegedly shared them with Apple and others. The remedy needs to level the playing fields. Otherwise, these lengthy and expensive monopolization cases are just sound and fury. They're nothing more. Just a couple of concluding observations, and then I think Teddy and I may have a little back and forth, and he may invite some questions, hopefully easy ones. For the case starting next week, the parties are fortunate to have drawn an experienced, no-nonsense judge, Leone Brinkman. I've never appeared before, but I led a delegation of 3 U.S. federal judges towards the end of my time at DOJ to China, where we interacted with their counterparts. And I watched her engage intellectually, how well she listened, and how appropriately self-confident she was in the way she approached her job. She's awesome. She's experienced and she's tough-minded. And some of her rulings, including on what to do about auto-delete with chat, said, look, I'm not going to go into a whole sanctions regime here, but I know what they did, I think is effectively what she said. And I'm going to think about that with every witness that Google puts on the stand. That's it avoids a side issue, but keeps it in play. So at the same time, I think we need to appreciate that DOJ, Google face an unprecedented 3-dimensional chess game right now. They need to litigate this case where liability and remedy are also combined, just like in Google search, while Google battles over liability with a very similar case pending in the Texas courts brought or led by the Texas AG. That's all going to be going on while DOJ and Google litigate over the appropriate search case remedies before Judge Mehta. There was a filing yesterday, Teddy and I were talking about. It was a joint filing about what the path forward should look like with DOJ and Google. The only thing jointly agreed to in that filing was that it would be titled joint filing, as you might imagine. Google, not surprisingly, wants to take a lot of time, but wants to make sure it knows everything about what DOJ wants before it has to do anything. DOJ, from its point of view, said, you know what we'd like to do is, within a month or so, come up with a list of possible remedies, get reaction from Google, and then direction from the judge so we can go take discovery about remedies make most sense. Google, knowing that was the government's position, fundamentally opposed it. But we're on a track where we probably aren't going to get, if DOJ has its way, to a hearing on remedy until next April. And so we could actually have this case still pending while the rocket docket gets to both a liability and a remedy finding. So the final point is it's just a lot to sort out, and I wish them all well, and I'm delighted to be here and not back on Pennsylvania Avenue having to worry about that myself. Thank you.
I'll just ask a couple questions, and then maybe we can take one or two from the audience. But one thing that's come up a lot today, and I would love to get your perspective, is the need to address conflicts of interest. And sort of the prevailing wisdom of the past 30, 40 years is that, vertical mergers are okay, they're mostly good, it's not that big of a deal. But then we have a situation here where, panelist after panelist is saying, hey, we really need to address these conflicts of interest, and you see a lot of that from the vertical power that these companies have. And so how do you think about, where we are intellectually at the DOJ and the courts, moving away from this idea that vertical mergers are okay to, hey, we really need to break these companies up and cut off their conflict of interest?
Well, generally on vertical mergers, I think the thinking has just gotten more three-dimensional, less theoretical. The notion that vertical mergers generate efficiencies is I think generally still an accurate proposition, but you got to look at the market structure and what the vertical integration is doing in terms of giving companies power at 1, 2, 3 levels of distribution. The whole pharma, the whole PBM, retail drugstore, mail order thing is a really good example of it's gone too far. The FTC is looking hard at that with its 6B inquiries, and I think is investigating efforts to do even more. I was, met Tim shortly after his participation. That whole thing about figuring out how incentives are aligned when it comes to a monopolist, whether it's a tech monopolist or anything else, and then how to craft remedies that change the incentives or redirect them in a way that is pro-competitive. And that may well mean saying, you know what, the vertical thing ain't working for the market. It's not working for competition. And that is part of the structural relief. And as a general rule, vertical structural relief may be easier to do than horizontal. Not a universal truth. But so I think that's got to be part of the discussion, and it probably is underappreciated as one of the sources of monopoly power, particularly in tech.
We also heard a lot about common carrier rules, utility-style regulation, understanding these companies as essential communication platforms. We've seen Republicans at the Supreme Court show some interest in common carrier rules for big tech, but there has been less on the Democrat-appointed judges on that, less interest or sort of a less robust curiosity around that. Do you think that that is a path that, judges should look at? I mean, it certainly seemed like a tool in the toolbox that we talked about this morning. Mm-hmm. Should that be more regular conversation among judges when they're making big decisions about, how to address the problems that we're seeing in big tech?
I think it makes sense as a possible approach where you're persuaded by history and by the evidence presented at trial that these markets are natural monopolies, and that if that really is, sort of breaking it up, and as I talked about, leveling the playing field and starting the race with everybody in an equal position, if that in 2 years is going to end up with the market tipping to one, then maybe it is a market that we need to think about regulating. But to your introductory point, it is ironic that Republicans who were all into free markets and accuse the Democrats of seeing a thing and trying to figure out how do I regulate it, as opposed to embracing free markets. It's a much more nuanced discussion right now, and that's appropriate.
Yeah. Do we have any questions in the audience? I have a few more myself. Oh, we've got one right here. Yeah.
Here's a mic.
Thank you very much. Thanks for the talk, Bill. And I'm curious, what do we do about speeding up the amount of time that these big cases take? And when you've bifurcated liability and remedy, what should we do there? Because in your remarks, you talked about the need for discovery, and that all makes sense to me. But delaying remedies means that the harms imposed on the market are continuing for longer than we would want them to be. And of course, we're going to have appeals. So what do you think we ought to do about speeding up the process?
Well, one could assign them all to Judge Brinkema, and would be one thing, although it's a lot of work to get this case as far as she's gotten it, as quickly as she has gotten it. Joel Klein's DOJ did a great job of getting the Microsoft case. Took a while to get it out the door, but they embraced an aggressive discovery and got it tried. The judge played along. The Court of Appeals played along, and that there are some models out there. And the challenge, having been an enforcer and in the room with some other enforcers, is risk adverseness. That tendency. Well, let's not do anything until we boil the ocean, and then we'll decide what to do. You got to take some risk, in part because of your point. This is ongoing consumer harm. If the government's theory of the case is correct, there is ongoing injury, and it needs to be stopped and it needs to be redressed. So I don't have all the answers to it, but I do think the agencies are trying their best in difficult circumstances. I listed all the cases that are pending, and that's just the monopolization cases. Those of us who worked at the FTC together, Bill and Josh are sitting out there, we didn't have the resources to do all we wanted to do, and they are trying to do a lot. So it's complicated, but I do think at the beginning and the end, it's your point. If there's consumer harm occurring, let's get after it. Let's get after it quickly, and let's not be afraid to take some risk in getting from point A to point B.
The stakes. We've talked a little bit on the previous panels about the stakes of getting this right, and using the framework that you had of reasonable remedy without unreasonable costs. When the stakes are, and I'm curious if you agree with what the other panelists said, that one of the stakes here is the robustness and diversity of the news industry, the survival of the news industry. This is much bigger stakes than what we saw with Microsoft. If you're in agreement with what we just heard earlier today, does that make it easier to, if you're DOJ, if you're a court, to push for and look at a really robust remedy? Because the downside here error really is to not doing enough potentially, or does that come in?
I think it comes into play, but the job of the government is to persuade the trier of fact that those concerns are legitimate. The ongoing harm, not just to consumers, but to competition, upstream harm, as well, is something that needs to be addressed. You need to convince the judge you're right, and then you've got to show him or her how to get there, how to craft a remedy that deals with the problem. While it took Judge Mehta a long time to get his decision out, It is, I've read it a couple times, and again, I've forgotten most of it. But he laid it out in clear and concise. He got rid of those parts of the cases which were a little bit marginal, and he made it easier to focus on the core. And that's a tribute to him. It's a tribute to the litigators at DOJ who showed him how to get from here to there.
One of the things,
Maybe one or two more.
we've got a question here, yeah.
Sorry, I'm running over.
He doesn't need a mic.
Thanks. I saw Judge Brinkman. I was very impressed in the way she handled herself, just very confident. Do we have a problem with big law, with all of this document production issues, with Amazon and doing the same thing that Google did? You have, deleted text with the Albertsons and the Kroger Albert. I mean, it seems like it's pervasive. I know our organization got a letter demanding that we stop talking about RealPage from
Saw that.
Gibson Dunn. There's a sort of a lawlessness among these big law firms, at least my perception. What do we do to change the legal culture so that their clients are not routinely shredding documents?
Well, I do think we need to have more consequences for bad actors than we've had to date. And I said, Brinkman is going to handle it in the way of assessing witness credibility. I think that's an issue too in Kroger Albertsons, isn't it, where the judge has kind of going in that direction. If that is done and is reflected in the opinions, I think companies and their outside antitrust advisors are going to have to, caution in a different way. In addition to saying be cautious about what you say, be a lot more cautious about what you delete, and no auto delete, none of that stuff. So we've got a ways to go, but it is a legitimate and serious problem. And whether we need to change the federal rules of civil procedure to up the consequences for bad conduct, those are things that I think should be on the table.
Can I add something to that?
Sure.
Because I spent my life in that hole, and the variety of ways in which you can absolutely protect communication is infinite. You're told to put the lawyers in copy, but also just the various formulation of that. What needs to happen is agencies in Europe, the judge possibly pierces that veil, because somebody needs to come out and say this stuff cannot be covered by legal privilege. The limitation of legal privilege need to be stated. It is not conceivable that every kind of form of, Economist report that contains bad news is kind of completely hidden by the fact that you've just written privileged and confidential and sent it to the lawyers instead of directly to the client. But there are millions of ways in which you can send it to the lawyers with various formulation, and then it doesn't get discovered. So I think the issue is really that somebody needs to come out and say, well, this stuff is bullshit. We will not accept it.
I'm prepared to say that. It looks like you already did.
Teddy, two more really quick questions. And then
Okay, great.
Sorry.
Real quick, Bill. You mentioned the technical committee in AT&T, and there was a similar committee in Microsoft.
Right.
Do you think, as part of any remedy that we're going to see in these Google cases, that there'll be the technologists in charge? There was this event, I think Remedy Fest, where the people who know the technology, the software writers and engineers were explaining how things could be different. And I think in Microsoft they had like 90-something outside software engineers in a company that with offices in Silicon Valley and Seattle to oversee any kind of implementation of the rules, the behavioral remedy in that. Do you foresee something similar so it's not, the DOJ doesn't become a mini FCC and has to go into Judge Mehta every time there's a change to the software?
Well, it's a terrific question, and I think if you look at the history of AT&T's reluctant compliance with some of that stuff and Microsoft's reluctant compliance, having a technical committee that advises the court and the plaintiff is really important, because what do I know from how to break up ad tech, right? I really don't. And if an order is in place and they say we can't do this, can't do that, it'll take us not 3 years, 6 years. The AT&T decree kept getting extended because they claimed they couldn't comply. Technical committee gets set up, and suddenly compliance is a lot swifter and a lot more effective. So they shouldn't be in charge, but they need to help translate for us ignoramuses, what really can and cannot be done in a reasonable amount of time.
One last question, we'll go to the next panel.
Yeah, thanks. Hi, it's Tim. You talked about the three-dimensional chess that DOJ's got going on. An additional element to that is that Commissioner Vestager looks like she's leaving. We know that she's not going to reapply, and that's kind of the end of her term. But the decision in the European ad tech case, where she's already said, look, I'm dealing with a recidivist, I'm dealing with something that needs to be addressed because of the ongoing conflict of interest, so we need to have a structural remedy. And there's even a nice little picture with a pair of scissors across part of Google in a press release. Now that was in the, prior to the statement of objections. We understand that that decision is being written. If you're looking at this, imagine you're now in the DOJ. You've got the whole of the, presidential election going on, and in the middle of that, the commission comes out with, here's a breakup Google decision. It won't probably specify the remedy, but what would your reaction? Would that be useful? Would it be distracting? How would you look at that?
Well, looking at Christina as I answer that question, but it's I think it'd be constructive. I mean, she made the point that the remedies Google in other cases may have been, in retrospect, too narrowly tailored, not bold enough, right? And so if they're going to do it now. It gives some impetus. Whoever wins the election to keeping the cases pending in the U.S. alive. So go big or go home.
Please give Bill
Thank you.
a round of applause.